Welcome! If you're getting ready for your Arizona real estate exam, then you are in exactly the right place. Today, we're going to build a bulletproof contract from the ground up and decode the legal essentials you absolutely have to know to pass. All right, let's kick things off with a question that honestly trips up a lot of new agents. So picture this. You and a seller shake hands, you agree on a price, you've got a deal, right? Is that handshake actually legally binding for a house here in Arizona? The answer to that is a huge, legally absolute no. In an Arizona court, a handshake deal for real estate is worth, well, pretty much nothing. And we're about to dive into exactly why. So here's our game plan. We're going to cover 5 key areas. We'll start with the very DNA of a contract, then get into why writing is everything. After that, we'll talk about the art of the deal, some major deal-breaking defects, and finally, what happens to a contract when someone passes away. Okay, first up, let's get into the foundational building blocks. Every single valid real estate contract in Arizona is built on 3 pillars. And you gotta have all 3, because if even one is missing, the whole thing can just fall apart. And here they are: offer, acceptance, and consideration. The offer has to be a clear proposal. The acceptance needs to be a total, unqualified yes to that proposal. And consideration, well, that's the value being exchanged. You know, the buyer's money for the seller's property. As an agent, your job is to make sure these 3 things are crystal clear in every single deal you write.
Now let's zoom in on acceptance, because this is a huge exam alert. Arizona is super strict about something called the mirror image rule. It means exactly what it sounds like. The acceptance has to be a perfect mirror image of the offer. If a seller says, "I accept, but let's change the closing date by 1 day," guess what? That is not an acceptance. Legally, it's a rejection of the original offer and the creation of a brand new one.
Okay, let's keep building on that. Now we get to the single biggest rule in Arizona real estate contracts, and it's the very reason that handshake deal we talked about at the beginning was completely worthless. This right here, this is the legal gatekeeper. It's a quote from Arizona law called the Statute of Frauds, and it is totally non-negotiable. If you want a real estate sale to hold up in court, the agreement must be in writing and it must be signed. Period. There are no exceptions. It exists to prevent, you guessed it, fraud. And in writing means more than just a quick scribble on a napkin. As you can see here, the contract has to describe the property with enough detail that a judge could point to it on a map with 0 doubt. A street address or an APN? That works. But something vague like my house in Maricopa County? No way. Specificity is everything. All right, let's wade into the negotiation minefield. We kind of touched on this with the mirror image rule, but let's really break down the incredible legal power that a counteroffer has. So let's set the stage. A buyer, maybe your client, puts in a solid, clean, written offer to buy a house for $500,000. It's a great offer. Now the seller sees the offer, they like it, but they want just a little bit more. So they write up a counteroffer for $510,000. Okay, this is the part you absolutely have to remember. The second that sellers submitted their counteroffer, the buyer's original $500,000 offer was legally destroyed. Poof, it's gone forever. The buyer can't wake up the next day and say, "You know what, fine, I accept my original offer." That offer doesn't exist anymore. The counteroffer killed it. So, you've got a signed, written contract. Everything's good to go, right? Well, not always. Even with signatures, certain problems can make the whole thing invalid. Let's look at these deal breakers, situations where the agreement isn't actually genuine. Fraud is a big one, but for your exam, you need to know that proving fraud in court is tough. You have to prove all 8 of these specific things, from a false statement being made, all the way to the buyer actually suffering damages because they believed it. A contract built on fraud can be thrown out by the person who was wronged. And here is another huge exam alert, and this one's special to states like Arizona that have community property laws. To remember this rule, just think about the number you see here, 2. For a contract to sell community property to be valid, you need 2 signatures, 1 from each spouse. It's called the joiner requirement. If you only get 1 spouse to sign, the other one can come in and void the entire deal. So a word to the wise, always ask about marital status. And finally, let's tackle a question that comes up more than you'd think and can be pretty emotional. What happens if a buyer or seller passes away before the deal closes? Does the contract die with them? This chart makes a really critical distinction for your exam. A purchase agreement actually survives death. Why? Because it's a contract for an asset, the house. The deceased person's estate is legally on the hook to finish the sale. But
A listing agreement is totally different. That's a contract for personal services between a seller and a broker. That personal relationship ends when someone dies, so the listing agreement is automatically terminated.
So as you get ready for your test, just remember, a truly bulletproof contract is way more than just checking off boxes. It's about making sure there's a real, genuine agreement. A famous Arizona case, Hill Schaefer, taught us all a huge lesson. You can have a contract that looks perfect on paper, but if the two parties had completely different ideas about what they were buying and selling, there was never a true meeting of the minds. And with that, there's no contract at all. So always ask yourself the question on this final slide.